Hello and welcome. You are listening to Passing the Baton. I'm Jared Hight from Tracktown Law, and today we're discussing what an estate plan really is, why every Oregonian and Idahoan needs one, and how you can start building yours before this episode ends. A quick disclaimer. I'm a lawyer, but listening to this podcast does not make me your lawyer. This does not create an attorney-client relationship. For advice relative to your specific needs, please contact a licensed attorney in your state. When most people hear the phrase estate plan, they picture a mahogany desk, a gray-haired billionaire, and a stack of leather-bound binders. In reality, an estate plan is simply a written set of instructions that answers two questions. First, who makes decisions if I'm alive but incapacitated? Second, who inherits my stuff, and under what conditions after I die? That's it. Money matters, of course, but control matters more. Control over medical choices, over who steps in to pay the mortgage, over whether your son gets his inheritance at 21 or 35, control over how smoothly life moves forward for the people you love. In Oregon, a foundational plan usually contains three core documents. Document 1 is a last will and testament. It speaks only after death, naming a personal representative, sometimes called an executor, who will gather assets, pay debts, and distribute what's left according to your instructions. Document 2 is a durable financial power of attorney. This springs into action the moment you cannot sign checks or manage online banking. Without it, your family may need an expensive court conservatorship just to keep the lights on. Document 3 is an advanced directive for healthcare. Oregon's statutory form lets you appoint a healthcare representative and record treatment preferences for end-of-life care. Some families add a revocable living trust. Think of a trust as a suitcase. You retitle your assets into that suitcase, your house, your brokerage account, maybe a rental cabin. Zip it up and carry it through life. When incapacity or death strikes, your successor trustee simply unzips the suitcase and follows your private roadmap. No probate, no public inventory, and no court delays. Trusts work great for blended families, out-of-state real estate, or anyone who values their privacy. Now, what happens if you skip all of this? Oregon supplies a default plan called intestacy. The legislature decides who inherits, the court decides who manages, and creditors have a field day combing through public records. Probate can stretch 9 to 12 months, even for modest estates. Worse, intestacy ignores unmarried partners, stepchildren, and close friends. A basic will eliminates that chaos in under 20 pages. Let's make this tangible. Imagine you own a starter home in Eugene, a Subaru Outback, and you have a 401k worth $80,000. You live with a longtime partner but never married. Without a will, Oregon gives everything to your parents. Your partner receives nothing. With a will, you can leave the house to your partner, the car to your sister who needs transportation, and the 401k to a niece as college seed money. Same assets, radically different outcome, all because you took control. Estate planning also evolves. When you marry, buy a home, welcome children, start a business, or move across state lines, revisit your plan. I tell clients to review every 3 to 5 years, or after any major life event, whichever comes first. Common myths deserve busting. Myth 1. I'm too young. Well, the minute you turn 18, no one, not even your parents, can legally act for you without paperwork. A durable power of attorney takes care of this. Myth 2. I don't own enough. If you own anything you care about, care enough about it to leave instructions. Myth 3. It's too expensive. A simple will and powers of attorney costs less than a weekend at the coast and can save your heirs thousands in court fees. So what's your action step? Start an asset inventory tonight. List real estate, vehicles, bank accounts, retirement plans, and personal items with sentimental value. Then jot down who should manage and who should inherit. Bring that list to an attorney, or at minimum, use it to complete Oregon's free advance directive form while you schedule the rest. If you'd like personalized advice on protecting your legacy in Oregon or Idaho, please reach out to me through tracktownlaw.com. I'd love to help you turn that asset list into a living, breathing estate plan. Next time, we'll look at who inherits when there's no will at all.